we're dating ourselves a little bit for those of you who remember the old Batman show, but I think that it's really very apropos to what we're talking about, managing a crisis and trying to help everyone think about ways of not making it so that we're having to send out that bat signal looking for some help. So, want to talk about a couple of things. When there is a crisis and when we are dealing with a loved one, someone in our lives, someone who we may be named to deal with the crises as it like a healthcare proxy power of attorney, we always have to begin by asking a couple of main questions. And when we get people who come to us to say, my loved one's in a crisis, we don't know what to do, we always begin with this first question. And it's really a medical question. Even though it has legal implications, it's a medical question. So we always start with looking at what is the level of competence for the person who's in crises, because our approach is going to change depending on what that level of competence looks like. So has the doctor, we always begin with, has the doctor declared this person competent at this point? If the answer is actually yes to that question, then we can do some pre-planning with the person. We can involve them. We can use this time to try to make sure that all of their appropriate estate planning documents are in place. And so we always want to begin by trying to involve them as much as possible with the planning portion, with helping us to kind of direct where their future is going. So many of you may be very familiar with these documents. They really are the things that we want to be able to put in place if a person is competent and can participate in planning with us. So these are the things that if someone comes to see us, even though a medical crisis may have occurred or is occurring, if the individual still has the competency to be able to participate in planning, that is our goal. We would like to have them participate as much as possible. And the more we can put these kinds of documents in place, even at that point, the better it is, so that we have the authority and we don't have to go through the next steps that I'm going to talk about. So what happens if the doctor has declared that the person is incompetent? So this is where we have to do some involvement of usually a court, and we have to move forward with some type of court proceeding. So I want to talk about guardianships and conservatorships. It used to be probably about 15 years ago and prior that guardianships and conservatorships were one action here in Massachusetts. And back in 2012, we actually separated out guardianship and conservatorship proceedings. And there was a couple reasons for that. One, guardianship is when we're making decisions about the person, very much akin to the healthcare proxy, making decisions about the health of this person, making decisions about end of life, making decisions, let's say, about where someone lives, that kind of thing. A conservatorship is set up to handle the finances for someone. And so legally, we separated those two responsibilities. One of the reasons that we went through this big change here in Massachusetts is, again, prior to 2012, there had been some reviews of the court system, and there had actually been a pretty strong Boston Globe spotlight on guardianships in Massachusetts. And it was finding that we were giving guardianships away a little too easily. We were putting people under guardianship without really doing the level of safeguard that was believed was necessary. So in 2012, one of the shifts that we made was to make it so that when there were proceedings started against someone, in order to be able to take away their rights and to make it so someone else was being named legally to step into their shoes, that we put much stronger safeguards around that whole process. So it wasn't just a rubber stamp by the courts to allow a guardian or conservator to be named. So let me talk a little bit about guardianships and conservatorships. Again, guardianships are very much akin to something like a healthcare proxy and being able to manage decisions for someone's being, about who they are, where they live, what they can do, those kinds of things, and very much about healthcare decision making. Conservatorships are about handling someone's money, and they're very akin to a power of attorney. And then I'm going to talk about a process that we use in Massachusetts called the affirmation of a healthcare proxy and how that works. But what we find with guardianships and conservatorships is that they are much more restrictive than when we're able to put in place a healthcare proxy or a power of attorney. And let me explain that. So, for instance, when we go to a guardianship proceeding and we have someone appointed to act as a guardian on behalf of an individual, unlike a healthcare proxy, the guardianship proceeding, first of all, is a public proceeding. It's in front of a court. You need to make sure there's medical documentation to show that this person is no longer competent to make decisions. The individual, we call them a protected person, has the right to legal counsel to be able to protect their interest. And so that's something that is part of the legal proceedings, is that legal counsel may be appointed for them. And legal counsel is always appointed for someone when we're dealing with a guardianship proceeding that also requests the use of something like antipsychotic medication. It's called a Rogers or Rogers Authority here in Massachusetts. And so sometimes that's a term that people have heard. So when we go for a guardianship proceeding, again, the person for whom we are acting against, or the protected person, the person who we are trying to say no longer has the competency to be able to make decisions for themselves, they are given, again, counsel when appropriate. They are given notice. They have the right to be able to be heard, to be seen as part of the proceedings, because we are taking pretty dramatic actions to remove their liberties. We also try in guardianship proceedings and conservatorship proceedings in Massachusetts to limit them whenever possible. So when we are talking about going for guardianship with someone and or conservatorship with someone, we actually do some negotiating when possible to leave certain decision-making aspects with the person. So for instance, let's say we go for a guardianship for someone. They are no longer competent to be able to make their healthcare decisions. But this may be someone who certainly can still participate in decisions about where they live, decisions about who they interact with, who they have in terms of visitors, who they're able to have communication with. We try to leave as much as we can with the person to honor as much of their autonomy as possible. So it used to be that with a guardianship, once a guardianship was in place, the guardian had full authority to be able to make decisions. Now we try to limit that where we can, enable to be able to honor when possible the participation of the protected person and their rights to be able to make some decisions for themselves. Because someone might not be able to understand the risks and benefits of healthcare decisions, but they may be able to say, this is where I want to live, or this is who I want to be able to interact with, those kinds of things. And again, with a guardianship, we have to go back to the court if we want what we call extraordinary authority. And there are certain things that fall under extraordinary authority. So for instance, if we are moving someone from their home, whether that be their private home or rental or assisted living, into a skilled nursing facility for long-term care, we have to get specific authority from the court to be able to do that. If the desire is, if the need for this person is that they take antipsychotic medications, and we want the authority for the guardian to be able to approve those antipsychotic medications, we again have to go to the court and we have to get explicit authority to be able to give the guardian that ability. There's also annual reporting requirements that are necessary. The guardians have a job to do, and their job must be reported to the court on an yearly basis. This is giving information to the court about how the person's doing, whether their needs are being met or not, and what changes the guardian thinks need to be put in place in order to be able to meet the needs of this person. If they're on antipsychotic medications for any reason, that also needs to be reviewed on an annual basis to make sure that it is still appropriate that this type of medication be given to the individual and that they're not suffering side effects to the extent that it is impeding their life. So very, very important to know that when we go down the route of guardianship and conservatorship, it is expensive from the beginning to go through that process. The protected person oftentimes doesn't have a say as to who may end up being their guardian and or conservator. And it's something that needs annual review and annual involvement of the courts, which is a good thing on one hand, because it means that someone is overseeing what's happening in terms of this guardianship protected person relationship, hoping to be able to stop any kind of abuse that may occur. But it also is time consuming, expensive. It's a lot of work to be someone's guardian. That's why if we can have someone put in place a healthcare proxy while they're competent, we want to do so, because that then allows the person themselves to choose the individual of their choice to be their proxy. It also doesn't require the same oversight. Once a healthcare proxy is in place, and as long as it is valid proxy, then we don't have that ongoing court oversight. It is something that is private with the proxy who you've chosen to do the job that you've asked them to do if it is needed. So we don't have that ongoing court oversight.
Kathleen, can I interrupt for a second?
Absolutely.
What's the ballpark cost for guardianship or conservatorship?
So it can be, it's very dependent, but ballpark can be somewhere around $5,000, because we have not only the proceedings itself, we also have the court fees. We also may have the fees associated with the appointment of counsel when the person is given counsel. Sometimes a court will appoint what is called a guardian ad litem. A guardian ad litem is typically an attorney who's appointed by the court to investigate the situation on the court's behalf. So this is where there may be, let's say, someone we are looking to have them admitted into a nursing home facility. A guardian ad litem may be appointed by the court to kind of be the eyes and ears of the court, to do an investigation to say, is this an appropriate decision to be made? What are the concerns? To speak with the protected person. So it can get very involved. That's the beginning cost. And then there's an annual cost. There's, if you're doing the reporting yourself, then you're going to potentially have a cost if there's a filing fee for any changes in your requests with the court. And the time consuming portion is putting together the reports that are needed every year to report back to the court about what's been happening as a guardian or conservator. So conservatorship proceedings, like guardianship proceedings, always begin again with a medical determination about someone's competence. But conservator is being appointed to be able to manage someone's finances. And this is where the court then would determine that the person can no longer handle their own financial affairs. So handling their daily monies, paying their bills, making investment decisions, retirement accounts, handling real estate, all of the things that go into someone's financial world. The conservator is appointed to be able to handle that. The conservator will have an annual responsibility of reporting to the court as to what they've done with the individual's money. So every year they have to present the court with a accounting for what was in the accounts at the beginning of that time frame, what they spent on behalf of the individual, what additional assets they may have gained, whether it be interest on accounts or finding accounts, that kind of thing. they brought into the estate, and then how what is left at the end of the reporting period, so that we have a starting point for the next year. So that needs to be done. The conservator may have to go back to the court to ask for permission on certain things. So let's say that the protected person owns real estate, and for some reason, the protected person can no longer live in their own property and the real estate needs to be sold. The person, the conservator, needs to go back to the court and get court approval before they have the permission to be able to do something like sell the real estate. So again, the biggest, there's a lot of hurdles that are in the way of a guardian and conservator. Some of them for very good reason. It's, again, we want to make sure that someone is keeping tabs on what this guardian or conservator are doing. They have a lot of authority, they have a lot of power, and they're handling somebody else's affairs. The downside really for the protected person, though, is pretty large. First of all, they don't have the say in a guardianship or conservatorship. In most cases, they don't have the say as to who's going to end up being their guardian or conservator. Certainly, if someone objected to the appointment of a guardian or conservator for themselves, the court is going to hear that and determine whether that is an appropriate objection or not. But oftentimes, by the time someone is in the court system, and there's actions being taken to obtain a guardian or a conservator, this person oftentimes doesn't have the level of competence to be able to participate. So getting in place that healthcare proxy, getting in place that power of attorney, that then allows the person to name their own individual to step into their shoes. But they have to be competent to be able to do that. So pre-planning is critical when we can, but so many times we find that people have not done the pre-planning and we end up in this court system of guardianships and conservatorships. Now, I talked a little bit about this thing called an affirmation of healthcare proxy. A healthcare proxy, again, is the document in which you name somebody to step into your shoes to make healthcare decisions for you. You put that document together while you're competent, and it becomes activated when you're incompetent. Well, a healthcare proxy, just like a power of attorney and a will and a revocable trust, can be changed by the individual at any time. And sometimes we find that an individual has begun to have issues. Their competency may be waning, it may be fluctuating at times, and they may, for a multitude of reasons, decide they don't want this person to be their proxy. They don't want to take the antipsychotic medication. They don't want to be admitted into a skilled nursing facility. They don't want this individual anymore to be their proxy, and they're angry and upset about it. Well, the process of affirming a healthcare proxy is a court proceeding, but we use it to say, court, when this person was otherwise competent, when they did have full faculty, they had chosen this person to be their proxy. Now they've lost their competency. That's one of the things that we're saying to the court. And we don't want their rescinding of that healthcare proxy to be honored because they're not, for a lack of better words, in their right mind and not making a decision rationally. And we ask the court to recognize the document, the healthcare proxy, that was put in place while the person was competent and was capable. And there's a lot of reasons why we would rather a healthcare proxy to be authorized than to go down the road of a guardianship. Again, remember, the healthcare proxy is where the person has named the individual of their choice. So ideally, this is the person they would want to have making healthcare decisions for them. Also, the healthcare proxy doesn't require ongoing court involvement. So once it's been affirmed, if there is any kind of controversy about the healthcare proxy and it's been affirmed, the court doesn't have to have ongoing oversight. So there isn't the need for those annual reportings that there would be if a guardian had been appointed. Also, the healthcare proxy usually has a much wider range of authority, such as the ability to be able to authorize the use of antipsychotic medications or to be able to authorize placement in a nursing home if appropriate. And again, you're avoiding having to go back to the court every time you're looking for that kind of approval. So affirming a healthcare proxy if there's any controversy about the proxy. So another reason we sometimes have to go for an affirmation is if we have two healthcare proxies. So someone had signed, let's say, a healthcare proxy with their attorney, put that in place. Later on, had gone to the emergency room for some reason, signed a new healthcare proxy, and maybe named somebody else. Well, by law, that second healthcare proxy rescinds the first healthcare proxy. But the first proxy may say, look, I am really the one who they wanted to be in that position, and I'm asking the court to recognize that. Another reason we may go for what we call an affirmation of a healthcare proxy is if we actually want to remove the named healthcare proxy. So there's somebody who has been named, and for some reason that person has become a bad actor. They're no longer acting in the best interest or really in the shoes of the individual for whom they're supposed to be making decisions, and they need to be removed. So we can use an affirmation of healthcare proxy process as well to rescind or remove a healthcare proxy, or to rescind a decision that a healthcare proxy may make. So there's a couple of different ways, but it all involves a court. If we need to go on an affirmation of a healthcare proxy, we're saying to the court, oftentimes we want this document recognized, but we may need to have changes like who the actual proxy is made. We may need to rescind a decision that they had made, or we're asking the court to actually affirm it and to say it is in existence and should be followed, and the person who's been named should be the proxy who's recognized. So I talked about this a little bit. If someone does need nursing home level of care, this becomes very complicated, whether we have documents in place or we don't. So some of the issues arising when we have documents in place. So let's say there is a healthcare proxy and there is a power of attorney. We usually don't run into issues with having someone admitted to a nursing home. It's more reminding the person who's acting in the capacity as the power of attorney or the healthcare decision maker to always make sure that when they're signing documents on behalf of their loved one, that they are doing so in that capacity, signing as the healthcare proxy, signing as the power of attorney. So it is clear that they aren't, let's say, on a financial document. You enter a nursing home, one of the things they want to know is how are things going to get paid for? Well, the person who is acting as the power of attorney isn't financially taking responsibility themselves for the payment. What they're doing is they're signing the document as the power of attorney and taking financial responsibility as the person who they're representing. And that's very, very different. So always wanting to make sure that if you're acting in the capacity of someone's power of attorney or healthcare proxy, that you are signing the appropriate legal documents and clarifying that that's the position that you're acting in. Now, when we're talking again about being a guardian or a conservator, and we're talking about things like a nursing home placement, remember, a guardian must get court approval before they're able to place that individual into a long-term care facility. And so it does require a court hearing. It does require that someone get that specific court approval to be able to act and put someone into a nursing home facility. When someone's acting under a under a conservatorship, and they're looking to do payment issues or to deal with payment issues for long-term care, they don't need to get court approval to do something like a mass health application, but they would need to get approval from a court to be able to sell real estate that may be there. Certain financial institutions, like handling the dissolution of a retirement plan, changing beneficiaries on something, may require additional court approval in order to be able to kind of bless the situation before it occurs. And there can be very good reasons when the conservator themselves or the guardian themselves wants to get court approval to be able to protect themselves from other people. So let me explain that. So let's say there is a decision to sell an asset, not real estate, but sell another asset, or to be able to give away assets on behalf of the individual. And again, the situation would have to be appropriate for the conservator to be making these decisions. But he or she may say, you know, in order to protect the decision that I'm making, I want to have a court say that this is okay. I want to have a court say that my plan is an appropriate one, because I want to make sure that if there were a rogue child or a brother or sister or whatever else who is not the named individual here, that they are protected in terms of the decision making that they are undertaking. So they may choose to go back to a court in order to get the court to actually review this and to say whether it's an appropriate plan or not. So going back to the court may be required in some instances, or it may be something that protects the guardian or the conservator from decision making that they may be undertaking. One of the things that we find, or one of the questions that come up, is oftentimes when in the middle of a crisis, can things like planning for mass health occur? And sometimes they can. It depends on the person's situation as to whether the planning that we do can also include asset protection. So for instance, if we have a married couple and one individual needs long-term care services in a nursing home facility, oftentimes, you know, the thought is, oh, we're going to lose everything. We're going to have to spend everything down before we're able to get on some kind of state assistance. And just a reminder, currently nursing home costs in Massachusetts are anywhere between about $13,000 and $17,000 a month. So from a financial standpoint, they're quite burdensome. When we have a married couple, there is oftentimes a lot of things that we can do, even in the 11th hour, to help protect assets. But if there isn't a power of attorney in place, and that power of attorney isn't broad enough, doesn't give enough authority, we may have to go to a court and get permission to be able to do certain things. So let me give you an example of that. Dealing with clients who the spouse had a retirement plan. And in order to be able to do some planning, some protection around that retirement plan and protect it from the long-term care needs for the healthier of the two of them, we needed to liquidate that plan. But the power of attorney had been done 15 years ago, and it didn't give specific authority to be able to take on this kind of planning, to be able to liquidate the retirement plan, or sometimes to be able to name new beneficiaries under a retirement plan. In that case, if the financial institution says this power of attorney is not giving enough authority, we won't accept it, we then may have to turn to the court and we may have to do either a full conservatorship or a limited conservatorship. In a limited conservatorship, we call it a single transaction conservatorship. And in this case, we're going to the court and we're saying, we don't need a full conservatorship. We don't need someone named to handle everything. There's already a power of attorney in place and it's being accepted in most places. But in order to be able to do this one thing, we need the court to be able to give us permission. And so with a limited conservatorship, the advantages there is that we're getting court approval and it's still a court proceeding, which can be a pain in the neck. But once that is done, there isn't the annual requirements of reporting to the court because it's only to handle this one thing. So we can oftentimes tailor what we're going to the court for in order to be able to just get authority to do one specific thing. Ideally, one thing to remind everybody, we always want to do pre-planning where we can. Pre-planning, the benefits again is that making sure that who you want to be in that important position is being named, or for your loved one that they've been able to name the person or people they want in those important decision-making positions. Also, the documents usually have a very wide range of authority so that they are covering many of the concern areas that I've just discussed, and we don't then need to have any kind of court involvement. So that's always the ideal. If someone is competent and can participate in their planning, it's really the way to go. But sometimes we can't have that situation and we've got an individual who is no longer competent, and we do need to involve the courts and get a guardian and or conservator appointed in order to be able to make the important decisions that have to be dealt with for this person as they continue to age and as their needs change.